Good afternoon, everyone. I'm Simon Young in the Faculty of Law. It's a pleasure to welcome all of you here. And by the very good turnout for today's event, I guess that goes to show that we have real concerns about extraterritoriality, US extraterritoriality. It's not just fiction, it's real. It's reached our borders. And I'm very pleased to welcome our speaker today, who has been visiting us for a couple of months now in the Center for Comparative and Public Law. Mr. Paul Backer has law degrees from Georgetown Law School, and he has 20 years of experience doing some really, really interesting work in the public sector, in the private sector. I'll leave it to him to give details. But his work has brought him to over 30 different countries around the world, advising on regulatory matters, corporate finance, et cetera, and no doubt he's had to come face to face with this interesting beast known as US extraterritoriality, and he's here to come explain this to us and also to possibly talk about what the response should be to extraterritoriality. All right, so Mr. Backer.
I've always loved these. As a former employee, well, to the extent the word employee applies to such organizations like IMF, IFC, World Bank, ADB, EBRD, USAID, DFID First. I've always loved these events. Somebody comes and tells you why what they do is very exciting. We all get together and we read our PowerPoints, making assumptions that all of us are probably just beyond excellent readers. If you want to copy, my email is here, but having about 40 minutes to get through a topic that should and can need a seminar for 2 weeks, well, 2 times a week for months. So basically, we're going to fail together. Extraterritoriality is literally the greatest story ever told. It's just sort of the impact alone. According to Wall Street Journal, $60 billion in 2 years. That's $60 billion in 2 years just from banks, without really any meaningful due process, without any really court proceedings, just because by asking really nicely, the US government can get $60 billion. And it gets you to everything. It gets you to sovereignty. And this is a topic that's in there later on, but there's a piece of legislation called FATCA, which the US government likes clever acronyms, and FATCA is actually Fat Cat. And what's funny about it is that the victims, or the subjects, or the targets, depends on your extraterritoriality, they share something in common. They're generally unlikable, they generally have a lot of money, and they generally just aren't really good at defending themselves, because themselves, if you even look at the beginnings, one of the first expressions of extraterritoriality, which is essentially the ability of a government to project its enforcement beyond its borders, is pedophiles. And the US government passed a law that if you go overseas and you have sex with somebody who's under 18 years of age, whether or not that's legal, when you come back to the US, you can be criminally prosecuted. And on one hand, somebody can go to a jurisdiction, engage in conduct that is not illegal in that jurisdiction, come back from that jurisdiction without any meaningful contact with the US beyond leaving it, and be prosecuted. On the other hand, that's a pedophile. And as a father of a 3-year-old daughter, my sympathy is zero. And, well, extradition. You have people who trade in drugs in, let's say, Colombia. They never enter the US. They never directly ship to the US, but they can be extradited and jailed, as Mr. Noriega subsequently was done many years ago, for this activity. And again, they were not in the US. They were not selling drugs in the US. There's reasonably low ability to prove that they had conspired with anybody in the US. But they're drug dealers. And you sort of, you travel down this path and you get to international banks, and you know what? They're international banks. They're just not very likable. And so this thing, it exists. It impacts just about everything. It doesn't have a language to describe it. What's interesting. It's sort of had a couple of conversations about extraterritoriality and what is it. And we haven't even settled on a lexicon. It's $60 billion in 2 years. We don't have words for it. because it's extraterritoriality, it's long-arm jurisdiction, it's cross-border jurisdiction, it's extraterritorial enforcement. There was even a law review article on something called extrajudiciality, or it was something invented by the author, but it made him more of an authority in that subject. So basically, since we can't cover the topic, what I would like to sort of leave with every one of you is broadly what it is, why it's relevant to you, why sort of your view on it is important, and how do you work with it? How do you use it? This rather exciting version of double-sided printout. So extraterritoriality is the ability to enforce your own laws and regulations outside of your borders. And what makes it interesting, what makes it very, very exciting, is that apparently what is going on now indicates the death of territorial jurisdiction. And this we will get into later on in the talk, but historically, you know, to be subject to Chinese enforcement, you had to do something. You have to come to China. You have to register a company in China. You have to get a banking license in China. You have to run, let's say, a payday loan scam targeting Chinese. For extraterritoriality, the nexus is using the internet. You're using the American correspondent payment systems, and therefore you're threatening the American correspondent system. Therefore, you're on the wrong side of our foreign policy and domestic security interests. Therefore, we can prosecute you. Which, on one hand, you know, it's an interesting logic chain. On the other hand, you know, if you're using your credit card, unless it has one of those rare and unique Union Pay stickers on it, if you use your credit card in Hong Kong to buy a ticket online, you're using the American payment system. It's there's a later on what I think is a wonderful example of sort of using the American payment system that I used to give to my Russian colleagues just to annoy them. So what it has done, what the application of extraterritoriality has done, it has brought penalties that are literally tens of billions of dollars. 60 billion just banks, just 2 years. There was, I think, a Citibank piece that said that the annual legal exposure from extraterritoriality is around $100 billion a year in legal risk. In other words, it creates $100 billion worth of people who are looking to sue you. But same large enforcement agencies. There's a wonderful story about FATCA, and sort of part of it, you know, with a complex, dry topic is you tell stories. The wonderful story is this, you know, when the banks went crying to Department of Treasury and to the Department of Justice and said, look, this FATCA thing, you know, bad enough you're ruining all our relationships. Bad enough we're effectively IRS agents. Bad enough all of this. But guys, look, you know, your own estimate, you're going to make $300 to $400 million. The compliance cost is $8 to $10 billion. This is crazy. You have a compliance cost that you've placed on us that's 20 times more than your best case scenario to get. To which the U.S. government said, yes, but we're not the ones paying it. You know, our cost is zero. Our cost is, so the economists tend to get a bit hysterical about the wealthy having to give their money to somebody else, described it as one of the greatest wealth transfers in history. There's actually an article that described U.S. regulatory activity as the greatest bank robbery in history, but that's, you know, a bit too personal. And which again gets us back to what is a very important factor in law, is that just unlikable defendants. You know, it's very hard to sort of mobilize, you know, it's another wonderful story when I believe AIG was near collapse. There were Senate hearings, and one of the bankers was asked, well, did you make this decision? And he said, well, it was above my grade level. And he was asked, how much money do you make? He said, I made $30 million that year. And the senator asked, who's above your grade level? God? You know, who's the next step up from $30 million a year? And so part of it was lawyers' fault. Because, you know, even if banks felt sort of uneasy, and they came to their lawyers and they said, look, you know, how big is this problem? And their lawyers said, look, you know, okay, how do you lose money? You go to court. You have a court case, you appeal, you have discovery, you have right to remain silent, you have this, you have that. It's probably not that big a deal. And this is one of the key topics, is the dichotomy between substantive, and again, because this is being taped, let's avoid words like real law, and courts, and regulatory law, and regulatory agencies. One of my personal examples of working regulatory law is that part of the sanctions against Russia was that it prohibited the export to Russia of high pressure pumps used for fracking. And we went to them and said, look, my client makes pumps, and what is a high pressure pump? And they said, well, it's a pump that has high pressure. And you said, but okay, look, you understand, horizontal drilling, right? You can have an oil well that goes like this, or you can have fracking that goes like this. How do you tell a fracking pump from an oil well pump? And the guy said, look, when it comes time to prosecute your client, we'll figure something out. And, it's unfortunately, they're not widows and orphans. So they failed. They failed at every step. BNP Paribas, I am convinced, and I actually know people there, they never believed that you could be fined $9 billion. That's you're talking about amounts that resemble, post-war settlements. They never saw it coming. They never realized how unpopular they are. They never realized the difference between being in court and being in kangaroo court. So basically, this gets us to legal ideas. The idea of extraterritoriality, what it does, how do we deal with it, how do we see it? And the lucky thing about law is that we're blessed, unlike all other professions. In what we do, ideas are important. If you do geology, or if you do architecture, or if you can have your own unique ideas about what an arch should do. Should it support a building, should it not support a building? They're largely irrelevant ideas. An arch does what an arch does. You don't put the arch in the right way, the building falls down and bad things happen. With law, ideas shape the world. And one of my favorite examples is what's called collateralized debt securities. It was the idea that you can take a mortgage and you can package it and you can strip it into different payment tranches, and you can sell them to the widows and the orphans and the great unwashed. And then it really doesn't matter who owes you money in a mortgage because you've made your money. And this idea had the impact of changing the cost of every piece of real estate in the world. Because if you have to go and you have to bring your sack of gold coins to pay for your house, you can raise one price. If you can get a mortgage and pay over 15 years, you can raise another price. If you can get a mortgage if you're unemployed and all you do is lie about your income, or have the person giving you the mortgage lie about your income, you get a third price. But the impact of ideas is the change of real estate for every single one of you in the room. Me, Simon, everybody. You rent, you buy, you sell, you lease. It changed the world. And part of it is, I was telling Simon before the lecture, is that my team did the first mortgage-backed securities in the former Soviet Union. We did it, we moved on. We didn't really realize what we had, unfortunately. Here, this extraterritoriality will change everything. It will change the way banks transact. And again, this is a current example, but as an example, if you're an American citizen, you can't have a bank account anymore outside of the US. You can go to a bank and you will be spoken to politely, they just won't open an account for you. One of the impacts on US nationals is that foreign companies, due to extraterritoriality, no longer hire American expats with what's called the grant of authority. Because if you have signature rights, you can drag your company into kangaroo court or regulatory agency, fault-finding proceeding, whichever term you like better. And one of the things, is about legal ideas is can they be heroic? And because Simon, introduced me, I find him to be a truly inspiring figure. Because one of the ideas that Professor Young is working on is a regulatory LLM program for Hong Kong. And if you believe in the one country, two systems model, it depends hugely on the uniqueness of Hong Kong. Hong Kong ability to raise money, to circulate money, to provide expertise. And if, through hard work of people like Simon, they make this program work, and Hong Kong becomes a center that can advise every Chinese bank how not to lose $9 billion overnight, he probably does more to support the uniqueness of Hong Kong than people, waving, let's say, an umbrella at a municipal building. But my personal view. So it changes everything. It changes the world. And this is a sort of, again, ideas are important, but language is also wonderful. This is a quote from an article. BNP Paribas pled guilty to criminal charges and agreed to pay almost US $9 billion to resolve accusations. In other words, nothing happened. There was no court case, there was no evidence, there was no prosecution, there was nothing. Nothing was published. And skipping, very, very far ahead in my presentation, it's again, because economists is, I think, the only sort of group of people that find bankers to be, cuddly and charming. They describe one policy as where it's unclear what they were fined for, unclear what they pled guilty to, and unclear why all this happened. It's just terrible. But so, and another interesting piece of language is that BNP Paribas was barred from conducting certain US dollar transactions. In other words, the bank lost the capacity to use US dollars. If you keep in mind that, and if anybody here is personally involved with SIPs, it's an interesting project, but it's just that. It's the Russian credit card settlement system that when it's, they got Huawei servers that melted during testing. They didn't break, they melted. The metal congealed and pooled, like it was essentially a Terminator movie without Arnold Schwarzenegger later appearing. So these are exciting projects, and you will see a lot more of them. But for current purposes, if you can't use the dollar, and you can't use the settlement system, and you can't use correspondent payments, and you can't use the internet, well, you're not a bank. You're not really anything. So it is the ability to impose limitless fines and vague proceedings, and to a lot of commentators, and this is sort of, if you don't have due process, it's not clear how these penalties are linked to any actual event. Why 9 billion? Why not 7? Why not 11? And it's one of my favorite quotes. It's the very last slide. The former supervisor of New York State banking, and he was also the first one, leaving after having collected literally tens of billions of dollars for the state of New York against foreign entities, said, his quote was, I was surprised how easy it was. And it really is, because it's sort of, again, and it's up to people like Simon to develop, is, Bank of China probably is reasonably good at going to court. It's probably very, very bad at regulatory proceeding in an agency. It's probably just desperately bad. So, that's an actual word, kerfuffle. So extraterritoriality, again, projecting of your power outside of your borders. There's a wonderful example. Sanctions are a subset, and Russian sanctions. What have sanctions against Russia done? They've collapsed their economy. They can't sell anything other than their raw resources. Stuff that grows or is dug out of the ground. Because no one in their right mind will buy anything if you're not sure if the person selling it to you is going to be in the banking system a month from now, or if you can get software updates, or if their mechanics can come out to fix it. So the economy is largely collapsed, and one of the sort of, depends on your point in the political spectrum, but illustrative moments was when the invasion of Ukraine took place. JP Morgan Chase, when the sanctions came in, they didn't know what to do, so they just froze all payments. One of the payments frozen was, one of the payments frozen was the Russian embassy in the capital of Kazakhstan, Astana, made a payment to SOGAZ, an insurance company. SOGAZ is owned by Gazprom, which is owned by the Russian government. So essentially, the Russian government in Astana was paying the Russian government in Moscow for services. And they got frozen in New York. So you can't even, you can't even invade a country nowadays without the American settlement system. You're just really stuck in a lot of ways. So the question that pretty much all of you kind of have to ask yourself is, how do you see extraterritoriality? I mean, what is it positive? Is it negative? Is it, are you offended by it? I mean, do you think it's wonderful? And something we'll return to, because all of you, if you become interested and you participate, we're actually, the field is being defined. The field as such is about 2 years old. And we haven't even gotten to a common language to discuss it. It's a bit like talking about real estate if you're not quite sure what the leaser, lessee, is. you kind of, you have terms, extraterritoriality, extraterritorial enforcement, cross-border jurisdiction, long-arm jurisdiction. We haven't even settled on how to talk about it. And so the impact and its growth are pretty much, sorry, it's just the copies are made back-to-back, which is a bit hard to manage. So it's a bit of a move from Pax Americana to Lex Americana, which, again, thing about academic lectures, at least the standard in Europe and the US, is it's what happens in Vegas stays in Vegas. This is not an attempt to persuade to a certain political viewpoint. It's not an attempt to find a good guy and a bad guy, but trying to be objective about it. America is moving from a Pax Americana to a Lex Americana. Pax Americana is you send tens of thousands of soldiers to Iraq, and they try to, if you ascribe positive intentions to Americans, they try to build a democratic society in Iraq with very mixed success. One of the recently discussed topics, apparently my government has spent $500 million to train Syrian resistance fighters who would fight the Islamic State in Syria. $500 million later, there are 5 of them in the field. There were 59, 54 got caught by the Islamic State. 5 are there fighting for everybody's freedom at $100 million apiece. Probably you could get any number of Syrian infantry divisions to fight anyone for that kind of money. But and the problem with Pax Americana is it's you get back people who are injured. You get back dead people. The beauty of, from an American governmental perspective of, let's say, again, Russia sanctions, is that you get to choke the life out of Russia and you lose no soldiers. And one of the things about sanctions, one of the things about extraterritoriality, is that in applying the punishment, you reduce the resistance to the punishment. By applying sanctions to Russia, America killed business working with Russia. So there is no longer a constituency to fight against American sanctions against Russia. It's, as an example, let's say you're in GE. You are, and one of our former clients in Russia, you do, I think it was 2% of annual GE sales were to Russia. Sanctions came in, that percentage went to 0%, roughly, 0 point something. So that means that everybody who had a position of power in GE, based on income from Russia, lost it. There is no GE constituency opposed to sanctions anymore, because that power, that authority, that money went to the GE section working with China, working with Indonesia, working with Vietnam, working with maybe Ukraine. And so when you think about extraterritoriality, it is very rapidly growing because it allows the US government to impact everything without getting back corpses, without getting back cripples, without getting back people who are psychologically affected forever, without alienating all of their relatives. And one of the nice things about it, it pays for itself. It is very hard to lose money by fining BNP Paribas $9 billion. As one US senator said, $1 million here, $1 million there, pretty soon you're talking about real money. If you take a $9 billion fine, probably you're making something. And this is one of the great things, and sort of goes to debate about extraterritoriality, is that, if they agreed to pay the fine, we can probably all agree BNP Paribas did something bad to somebody. And that's a good thing. You see justice being done. But out of that $9 billion, exactly 0 goes to any victim of what BNP Paribas did. It's a bit like paying, a US regulatory agency. I'm sure BNP would disagree, but hypothetically, let's say they are a bad guy. So somebody gets $9 billion to go beat them up, but then they keep all the money. It doesn't go to anybody who lost money from having, foreign exchange or LIBOR or anything else manipulated. So the nice thing about extraterritoriality, it pays for itself and pays for itself lavishly. If the New York State can collect tens of billions of dollars for things like, one of the fines was that I think UBS was forced to pay because they were helping US citizens avoid US taxes. If one was cynical, and I'm not, one could ask, what exactly is the obligation of a Swiss bank to help the US government collect its taxes? Last time I checked, the US government the IRS has armored and armed units. They probably have helicopters. Why is it UBS's job, or USB's, to help them collect their taxes. And even if they didn't, why do they have to pay New York? And this is, again, because they agreed to it. You know, they said, okay. And it gets us, and it's a very long argument that I've had with colleagues for 20 years that I've been working as a lawyer. I've always insisted international law, unless you're dealing with Antarctica or nuclear missiles treaties, international law doesn't really exist as such. There's no such thing, because if you are selling sardines from Norway to China and you have litigation, you either have a China legal issue, somebody didn't pay, you have a Norway legal issue, somebody didn't ship sardines, or you have a shipping issue, you know, they didn't get to China. You don't have a European Court of Human Rights issue. You're not before some august tribunal, you know. The War Crimes Court at The Hague is not looking at your sardines. They may be enjoying them if they didn't make it in the shipping. But there is one moment, and I think it's universally agreed, recognizable moment of international law, which is this. This arguably is the most important thing that happened in international law ever, from its beginning. And what it was is, after 30 years of very, very nasty, bordering on civil war in Europe, a lot of small, you know, German and other states got together and said, you know what, we kind of need to end this thing. Because the problem that we're having was a religious war. And the Catholics, they were fighting for the souls of every person trapped in Protestant countries. And the Protestants were fighting for the soul of every person trapped in Catholic country. So you were fighting heretics. You were fighting people who rejected the glory and, you know, the passion and sacrifice of God. These people had to be extirpated. It was almost the first example of absolute warfare in Europe. And to have everybody live together, they agreed on a very interesting principle. You have your country, and what you do there is really largely your business. And this is a model that, as an American, I'm a huge proponent of. You know, that we've managed to export almost worldwide. And it's not really that controversial. Kissinger wrote a book about it, The New World Order. It's really very nice if you get a chance. But the idea is that you get to govern your country. You don't get to do genocide. You don't get to, you know, do what Cambodia did or what happened in Rwanda or what the Germans tried to do to the Jews. But outside of, you know, the sort of the wildest parameters, you get to run your country. And part of extraterritoriality is you now have the US running every Chinese bank. Every Chinese bank that has to get a W-9 form to its US clients is acting as an agent of the US IRS. And again, I'm not saying that this is bad, we should all fight against it, or this is wonderful, we should all embrace it, but it's a fact. If somebody is able to tell you how to run your business, they're regulating you. So that means that for the first time, in almost, you know, 300, 400 years of trying to get along together, you now have America, and later in the talk I will argue that everybody else will join the club, telling countries how to run their banks. And surprisingly, Chinese regulators don't love it. You know, surprisingly, IOSCO, which is the International Organization of Securities Commissioners, something, they don't love it. They're sort of, you know, one of the things America has, it says, look, you know, we're not going to tell your financial institutions how to run themselves, providing your regulation is equivalent to what we have. And one of my colleagues who works in the Vietnam, for some reason there's some hurt feelings between Vietnam and America to this day, who said, wait, so I don't understand, you know, you will evaluate, you know, my regulations? And the American counterpart said, no, it's equivalence. We're just going to see if they achieve substantially the same purposes. And my colleague said, well, he's describing conversation. So again, clarify for me. So is there like a letter grade? If we pass the good law, we get an A, and if it needs approval, we get a B. And, you know, if you don't like my law, do I have to add another law? You know, it's sort of the idea that somebody can come to your house, your country, your borders, and tell you how your financial institutions should run themselves. And again, banks are very serious business. Banks are, well, until the 0% interest rate policy of Obama, this is where people kept their money. You know, banks are pensions. Banks are everything. And all of a sudden, you have entities that have absolutely no connection to your laws. They don't know them, telling you what to do. And again, it's just sort of, you have working moments. There's a wonderful aside. One of the extraterritorial bits is what's called the Dodd-Frank Act. In it, what's called the Volcker Rule. What the Volcker Rule prohibits is a bank cannot trade securities for its own account. Why? Well, you play in securities, you get in trouble, and then we have to save you again. So you're safer. There's no set of laws, though. It's about market makers. For securities, major financial institutions have to serve as market makers. If I want to sell you my shares, or if I want to sell somebody my shares, and nobody wants to buy my shares, somebody, the market maker, has to come in and buy shares. So that means that major financial institutions worldwide have to buy shares. But they can't. But they have to. So they came to the SEC and the CFTC and the other alphabet soup agency, and they said, guys, this is kind of makes us nervous. What do we do? And they said, what's the problem? You're not being prosecuted. And they said, but the $60 billion in 2 years, $9 billion, it's all this money you have to find all at once. Just give us guidance. And the SEC said, yes, no problem, reasonable. You can buy reasonable amounts of stocks. And they were asked, what's reasonable? What isn't unreasonable? And that is a standard. And when they come to you, it's, there's a wonderful, it was part of a Jewish poem in Germany, is that it's not so important whether or not you feel that you're a Jew. It's important whether a guy with a stick feels that you're a Jew. And this is, the kind of regulatory approach we're seeing now, is that it's reasonable until they decide it's unreasonable. And this is a much longer conversation, and because there's a microphone, I don't think we should get into it. But one could spend a lot of time discussing the comparative qualifications of a U.S. federal judge versus some guy pulling GS-12, out of some fundamentalist evangelical school who is interpreting his regulations as he goes along. I am much more in favor of the judge. I am much more in favor of stare decisis. I'm much more in favor of published opinions. So this thing is happening. We're shaping it. And we kind of, so it's not like substantive law. It continues to grow. It makes money. So what is it? Oh. Okay, so it gets us sort of back to ideas of law. And you have to ask, what is law for? As you see it. Is it, for efficiency? If the law is for efficiency, then extraterritoriality is wonderful. There's one set of laws that has proven to work in large, well-regulated, affordably regulated markets. It's American laws. With all respect to the Vietnamese securities law, which I helped draft for the European Union back in the day, they've been at it for 10 years. The Americans have been at it for 200. If you see the purpose of law as efficiency, then logically you should embrace extraterritoriality. Lex Americana is probably the best thing that ever happened to anybody. It punishes the wicked. It punishes them so severely that they wake up, remembering how they were punished. And it's wonderful. You can also see law as a validation embodiment of local values. The Chinese way. The thousands of years of culture that have developed unique viewpoints and approaches to unique problems. And, and this is not inherently illegitimate argument. I mean, I would argue that once you get into Sharia law and you're chopping off somebody's arm for shoplifting, you're probably outside of the acceptable range. But the vast majority of national systems reflect national values, and they're not chopping anybody's arm off. So then probably extraterritoriality is a terrible thing, and it may be a threat to sovereignty, and it may violate the Westphalian Agreement, and it's just really, somebody in your house for no apparent reason telling you how you put the dishes up in the cupboard and when the cat should be watered and fed. Or perhaps law is looking for the right answer, the justice and everything. Fair, unfair. So maybe different kinds of extraterritoriality. There's one thing to remember, though. Corporate finance is integrative. As I used to teach corporate finance law, and one of the first lectures is that if you're doing corporate finance and you found a way of doing corporate finance that's unique, interesting, and exciting, you're in one of two situations. Either you're a genius and the other 100,000 of us out there are idiots, or the other way around. Statistics are very strongly not in your favor. If you find your unique way of writing Eurobonds, so an analyst has to spend 12 hours instead of 2 reading because you've created this literary work of art, you have doomed your client. Unique Eurobonds, unique IPOs, unique and cleverly designed collateralized securities, it's a way to your client's ruin. It's one of my favorite questions, because we do some government work and you get asked if you're a famous lawyer. And I was kind of wondered, how do you become a famous corporate lawyer? I mean, short of having your client walk out in handcuffs on television in front of you, how do I become famous? And if anybody has an answer, please, the email's right there, because we can use the business. It's a challenging time. And so the problem is, the field is being developed. It's impacting everything. We don't even have a language to talk about it. And a lot of it depends on how every one of you here sees the law. Because, if you sort of decide to weigh in now, probably, and hoping that the regulatory program does take place and Simon succeeds in putting it together, and it works, that they will have an extraterritoriality course. The way it is taught will shape the view of people who will have the premier roles in shaping it. Because if, let's say, I'm a Bank of China and I'm hiring a lawyer, I am much more interested, in a lawyer who can explain to me what FATCA or what RICO or whatever means, than somebody who can't do that. So how you teach it, how you perceive it, how you write about it, will be decisive in how it's shaped. So back to extraterritoriality. It is the greatest story ever told. It has everything. It has warlords, sanctions, Russia, the mad mullahs of Iran. It has drugs, extradition. It has international adventure and intrigue. There is nothing more intriguing than going to sleep not knowing if you have to pay somebody $9 billion. There's intrigue just beyond intrigue. So it is the greatest story ever told. And this is the substantive part. It's the activities covered, subject companies, enforcers, impact, jurisdiction, enforcement. And if you want, the presentation is available. Just drop me an email. There's also going to be a 20, 25-page paper based on whatever feedback we get from you. So that will also be available. So what are the activities covered? Civil litigation, torts. There's an Alien Tort Act that decides which tort actions you can bring in the US. Now, taking a step back, every discussion, extraterritoriality, gets you back to territoriality. The principle that we are not the boss of anyone outside of our jurisdiction is not an entirely stupid principle. We really don't want the US taxpayers having to pay the costs of everybody worldwide who wants to come and complain in US court. That means that that courtroom, that jury, that judge, that policeman, that janitor who cleans it, the real estate, all of it is not available to US citizens and paid for by US citizens. So the courts have been absolutely clear throughout. And they've sort of, said that, look, US law does not bind anybody outside of the US unless it says so. Or until somebody just walks around them. Anyway, so anti-money laundering, anti-bribery, which is the FCPA, anti-tax evasion, FATCA, which is every bank in the world now, anti-terrorist financing, antitrust, criminal prosecution, RICO, drug trafficking, sexual exploitation of children. I think in my paper there was a release from Justice Department that they have prosecuted 16 people to date. Data protection, derivative swaps under Dodd-Frank Act. And this is one of the funnier moments. We're out of time. But in the discussion, if there was going to be one, there is a moment that the UK regulatory authorities are now sharing fines with the US. So they've sort of developed this, harmonious relationship where, this guy gets 400 million, this one gets 500 million. This makes other regional blocs a little crazy. It makes the Chinese a little crazy. It makes the European Union a little crazy. Because, well, first of all, it's just, some guy in my house telling me, how to feed my cat. But the other part is, well, if they can come to my house, why can't they come to their house? So it's sort of, one of the very exciting experiments is this Chinese international payment system. If it works, it may actually give some remedies to people like Americans outside of the US who are shut out of the banking system now. So subject companies. Any financial institute, any company that's on the wrong side of if you're shut out of the corresponding payment systems, you don't exist as a bank. So the argument is the corporate equivalent of the death penalty. Who it's enforced by. The alphabet soup of agencies, state agencies, and the most interesting one is the US-UK alliance. Impact. It's my favorite part. In May 20, 2015, 6 banks agreed to pay $5.6 billion for foreign exchange manipulation for breathtaking antitrust violations. Same item by The Economist. No individuals charged with any crime, and some confusion as to what exactly the banks were admitting to, and to what effect. So, and that is the dichotomy of regulatory versus substantive law. Regulatory law enforcement differs in quality of staff, in due process, in everything. So the $60 billion number is from the Wall Street Journal. That it's $60 billion in 2 years from banks alone. There was a rather interesting case where Rabobank, and as disclosure, we're in the process of litigating against Rabobank on related issues, so not characterizing their conduct, but Rabobank paid a $1 billion settlement for manipulating LIBOR, I think in Hong Kong. And that employee actually took the time to, this year, travel to the New York court and plead guilty in New York. How that works, no one exactly knows. But getting back to 2015, Benjamin Lawsky announced $2.4 billion fine, fired employees for FX manipulation. This is the good part. Who gets it? So the New York State gets $485 million because Barclays manipulated FX. It may be available to a more closed set of participants, but what the exact connection between Barclays FX manipulation and New York State and $485 million, it's not clear. It's not published anywhere. Commodities Futures Trading Commission gets $400 million. U.S. Department of Justice gets $710 million. It's good to be a lawyer. U.S. Federal Reserve gets $342 million, and UK Financial Conduct Authority, the former, I believe, UK FSA, gets $441 million. How? Why? Well, they just do. So this gets you back to territoriality. Is that historically you had to do something to have somebody be the boss of you. You know, you had to come into territory. You had to ask for a license. You had to target somebody's citizens. Now you don't. There was a rather interesting court discussion whether or not using email is enough for jurisdiction. The court decided no. Courts are much more conservative jurisdiction than regulatory agencies. But the discussion was that the people discussing it were not in the US, but they were using email. And apparently the email, when it travels, one of the servers, which are completely invisible to the people writing the email, is in the US. And having this criminal conduct take place through the server, it jeopardizes the US financial and banking system, and redress must be sought. You know, and this was a criminal case. Again, luckily the court tossed it out. Much worse odds if it was an agency case. So, and this, again, it's not meant as an attempt to be clever or funny. You have moved away from jurisdiction by volitional act, by choice, to jurisdiction based for regulatory purposes. For example, sanctions, which is strict liability. You don't have to know you're violating sanctions to violate them. One of the more interesting things about sanctions is that sanctions against Iran, formerly and probably in the future against Russia, prohibit the facilitating of transacting. Whether or not providing legal services facilitates transacting and violating of sanctions, because negotiations certainly do. If you are a principal negotiating with an Iranian principal, you violated sanctions. If you are a US lawyer representing a US principal, not clear. Maybe, maybe not. But you've moved to jurisdiction based on things that are just very close to being intangible. One of the things about the jurisdictional debate, and this is, you know, this is not a made-up thing. I read a law review article about Bitcoins, where the author was talking about, you know, how do you build a robust Bitcoin system? Simple. Global application of US criminal laws. I mean, to me, as somebody who went to law school 20 years ago, this is heresy. You know, it's just crazy talk. You know, the idea that a nation would impose its criminal laws outside of its jurisdiction, it's crazy. You don't make laws that you can't enforce. You don't make laws that you can't predict their operation. And why in the many names of the higher power must we as US taxpayers fund imposition of criminal law in Bolivia, Brazil, Benin, and other places starting with the word B. You know, we're not the boss of them. So courts have been very reluctant. Courts have been clearly, for almost a century, reluctant on this issue. And again, one of the good arguments is that why would we possibly want to subsidize cases brought by anyone worldwide in our system? Why would we pay for it and deny our citizens the use of our own system to resolve what? I mean, it is absolutely, you know, tragic if something bad happens to somebody in Brazil, but it isn't our business. The Westphalian Agreement, which the U.S. probably never subscribed to because it was several hundred years before we were really around, but you know, the Westphalian Agreement sort of says that you don't go into other people's house. And the problem with regulation is that the argument that, you know, we need to pay for this, we can't pay for it, it's none of our business, it fails because, again, you get $9 billion for asking. I mean, imagine you're, you know, this Lawson guy in New York, and, you know, you go to your governor, and the governor says, so what have you done for me lately? And you say, I got you $9 billion. You know, this is not a bad way to promote your career. There are not a lot of disincentives for New York Department of Financial Services to fine people $1 billion. What do they lose? It doesn't cost them anything. You know, they don't really even have to go to court. So the U.S. Supreme Court said, governs domestically, does not rule the world. The Southern District Court, it's the trial level court in New York. It's a bit confusing because sort of for us, well, the New York State Supreme Court is actually a trial court and federal system. But so in the federal system, New York Southern District Court gets a lot of good financial cases because that's where Wall Street is. That's where all of our financial institutions traditionally were. And they said that, look, we start with the proposition that laws of any jurisdiction apply only to activity within its borders, unless the law says otherwise. And in 2013, the Second Circuit Court, which is the appellate court for the Southern District Court, said, absent signatory of Congress, the federal government cannot prosecute foreign activity. It doesn't seem to be that complicated. It doesn't seem to be sort of, you know, that. But the problem is that that's one of the reasons why the court system stopped being, well, it didn't stop being used. You know, antitrust is still there. Tort that comes under the Alien Tort Act is still there, which is mostly high water cases. But the blockbuster stuff, it's now going through regulatory agencies. And the enforcement standards are really wildly different because, you know, if you go for antitrust, you're in a courtroom. You have the right to remain silent. You have a right to discovery. You have a right to appeal. You have all kinds of rights. If you are violating sanctions, you're before OFAC and Department of Justice. It's strict liability. It's one of the sort of, you know, legally it's roughly analogous to possessing child porn. You know, there are two other, you know, strict liability items, you know, in U.S. sort of criminal law. It's child pornography, statutory rape, and, well, I guess now sanctions. And what the law is that if you have child pornography, regardless of how you got it, you violated the law. No one cares why, no one, and they shouldn't. I agree with the law. You know, you are guilty. You have it, you're guilty, you go to jail. Don't tell us why. But when you're using that standard for complex financial transactions, you're getting yourself into a little bit of trouble. You're sort of, you know, walking away from the traditional way of doing things. So they're very different. And a lot of commentators hold regulatory enforcement to be destabilizing. Because court hearings, what does a court do? Court has a process. Court publishes an opinion. There may be dissent. Their documents are available. If you're a lawyer, you go, you read up, and you say, aha, okay, this we don't do. This we do. Okay, great, now I know. Regulatory action doesn't have that. All you're told, some guy stands at a podium and says, today, BNP Paribas paid $9 billion because they're bad people. And I'm not saying they're not bad people. But what I am saying is you really lose something when you don't have published opinions, when you don't have rationale, when you have administrative personnel who don't necessarily have a legal or a good legal education, you know, administering all this stuff. When you have people who are clearly incentivized to produce blockbuster fines. Because the superintendent of New York, who I tend to mention a lot, has now left and joined a major law firm to protect clients from the New York Department of Financial Services. Though, sorry, in fairness, I am sure he will take all actions to ensure that there is no conflict of interest and will act in an appropriate and judicious manner. So, what drives application? Why, you're going to get more of extraterritoriality? I'm trying to be interesting. I'm losing you. Can you pass? So, what drives extraterritoriality? It's bloodless. A lot of our transacting was in Russia. And sort of having been around there for a lot of years, we know people in the American foreign policy community. And there were people who said that, look, this whole thing, you want to subsidize the throwing out of this president of Ukraine, who's a bad guy. He was a bad guy. But, you're gonna unsettle things. And you're gonna get worse outcomes. Because you throw out this guy, and something, we don't know what, but something bad will happen. And it did. You threw out the bad guy, and then you got Crimea, and then you got Donetsk and Lugansk, and then you got 1 million refugees, and you got 7,000 dead bodies in the middle of Europe. This is a bad thing. Guys with ski masks walking around, taking millions of people hostage, can be characterized as a bad thing. I may have to go back to Moscow one day, so we must not be, critical. So it's bloodless. It's also very popular. If you are a bank client, you spend most of your life being manhandled by your bank. Before coming to Hong Kong, I was advised that my bank charged me a $4 fee for an emergency deposit of my firm's cash. And I asked them, I said, well, what do you mean? And they said, well, did you want to deposit it quickly or not? And I said, well, why would you charge me for this? And they said, well, if you don't want to pay it, we'll just take it off the statement. It doesn't, and they do stuff like that, and it doesn't endear you. It's like, no one, after the airlines stopped giving you free luggage, no one likes them anymore. No one likes the banks. And if you punish the banks, it's popular. And these are huge foreign banks, pretty much the definition of unpopular and defenseless. A very big issue is technological capacity. It's actually an issue that got me started on. Intellectually, what interested me initially was convergence. Why do all securities laws start looking the same? And why, Chinese securities laws and Vietnamese and Ukrainian and Russian and US largely are the same. Disclosure, shareholder rights, because efficiency, because integration. And one of the things that makes extraterritoriality work, imagine you did FATCA. Imagine you dictated to every bank in the world that you must send me all documentation on US clients. And they did. And they sent it to you in Polish and zloty, in Russian and rubles, in dinars, in gachas, in kwachas, in frozen chicken, whatever the currency is of the moment. You couldn't make it work. But now you have transacting in one language. You have transacting in one currency. You have almost unlimited document storage capacity. You have almost unlimited document gathering capacity. You have almost unlimited document processing capacity. So what that means is that regulatory enforcement is profitable, and that's why you will have more of it. Whatever clever arguments, whatever whiny, Westphalian, you just visualize the scene. You stand in front of the New York supervisor who just got an attaboy from his governor for $9 billion or whatever $1 billion fine, and you say, Losky, come on, the Westphalian Agreement. It ended the 30 years of religious strife in 1648, and you're walking away from it. It's not a winning argument. Arguments made to governments starved for revenue, clever debating points will avail nothing. Anybody who believes that after proving you can get $60 billion just by asking, people who did it will stand down is delusional. It is an end of history argument. And you can genuinely believe that when the Iron Curtain fell, that the world was magically transformed, history ended, which is disappointing for the Jews, 5,000 years, for the Chinese, thousands of years, but it ended the history. It's brand new history. It doesn't end. It's history. It continues. It goes on. And this is the thing, that this makes billions of dollars easily. It will continue. It enables a state to impose its will without losing soldiers, without losing political capital. It will continue. It is popular. It is one of the things about Russian sanctions, which again, keep coming back to this topic I worked on, they are popular in the US. Because in any election with a two-party system, which I highly recommend if there's a possibility to acquire one, you have about 42% who are Republican, 37% who are Democrat, sorry, 42 Democrat, 37% Republican. So you got like 20% in the middle who decide everything. And what happens is that you have sanctions against Russia. Okay, the Russian speakers, you know, the Jews, some for, some against. Russians, some for, some against. Ukrainians, they're all for the sanctions. Poles, Lithuanians, Latvians, Estonians, Moldovans, they're all for the sanctions. Nobody in political life in the US will gain one vote by being against the sanctions. Nobody will make the argument. You will have more sanctions because it allows the government to punish people whom it sees as bad actors. And again, I'm not insisting that they are in fact bad actors. I know there are various viewpoints. But it enables the government to punish them without bringing back dead, emotionally and physically crippled people. This is very popular. Okay, 5 minutes. So, lack of consumer compliance costs. So what will happen? It will apply to more things. And this is one of my favorite examples. It is one of these things, you know, it's brilliance. One of the parts of Dodd-Frank is the whistleblower program, which tells you that if you turn in your employer, who's a bad guy, you can have a share of what we collect from him. We have had, up at a certain point when the article was written, 6,000 people applied, of which 6 were accepted into the program. The other 5,994 are working through the career damage that they've caused themselves. But I'm sure they'll be fine. Continued shift away from the courts towards agency enforcement. Governments don't like courts. The US government doesn't like the US courts. US judges, to be a US judge, you either have to be elected or appointed. You're roughly 20 years in. Most often you're a millionaire, and you tend to be uncooperative. A regulatory employee is making, it's fairly compensated for the important work he does in protecting the legitimate interests of our government and people. Making whatever he's making, but he's in a much more vulnerable position. The idea of an uncooperative regulatory at-will employee is somewhat, difficult. So they found how to make it work. It works faster, it generates more revenue, it is more predictable. Whistleblower programs. For example, right now, if you work for, let's say, JP Morgan Chase in New York and you report them to SEC, you're a whistleblower. If you work for JP Morgan Chase in Hong Kong and you report to SEC, you're not a whistleblower. Obviously, if you can get 6,000 people telling you how to generate tens of billions of dollars a year, they're going to expand it. And this is where you get to an interesting part. And to be honest, I am stealing this thought from your colleague, Douglas Arner, because he was the first one who said and just impressed me to no end, is that the main driver for unitary standards is banks. Banks don't care what the standard is. If you have to bring in a client and chop off their pinky and include it and send to the IRS, well, people want banking, they will give up their pinky. And besides, you can make the client pay for the amputation or whatever's involved. They don't care what the standard is. They want one. If it's an American standard, Chinese standard, Polish, Russian, German, it doesn't matter, as long as it's one. As long as we can comply with it and get on with our life, charging fees and generating revenue. But there is a very powerful force for disunity, and that force is the regional blocs, the EU, China. And they look at the situation, and it's one of the very funny moments, like with swaps, which is literally hundreds of billions of dollars a day that go back and forth in swap transactions. And the US passed Dodd-Frank and says, okay, one side must report what's going on. And the Europeans said, 2 sides, the buyer and the seller. I mean, it adds nothing, but it, underlines their independence, their free thinking. And so now, how many sides report? 1 side or 2 sides. So the European banks took the somewhat the Solomonic solution that they will report 2 sides, to which the US government said, no, we don't want 2 sides, we want 1 side. Don't send this to us. And you get into these things, and they're somewhat funny, but at the same time, I mean, this is a real problem that China is going to have to address. Can somebody come into their house and run their banks? Increasingly, And when we say banks, I mean all financial institutions, broker-dealers, hedge funds, equity funds, anybody handling large amounts of money through the US payment system. So there's going to be pushback, and you're seeing it. SIPS is part of that pushback. Union Pay, though, it much predates SIPs is part of the pushback. What is very likely to happen, and what is going to be probably a very large field of work for Chinese attorneys, is how does the Chinese government respond to this? You know, if you don't like somebody threatening to kick you out of Visa and MasterCard, you have to have your own option. If you don't like somebody threatening to kick you out of a correspondent account, you have to have your own option. So most likely these things are going to be implemented and grow. Or EU, China accept some diminution of their sovereignty, which emotionally is difficult. So anyway, we sort of, drivers got mentioned, responses. And this is one of the things, and sort of should be my final comments because we've taken up all the time. Responses. You can't keep getting hit with $9 billion, $2 billion, $5 billion fines. You can do one of two things. You can stop the misconduct, but, well, and the banks are working to stop the sorry. You can stop the bad things you're doing, but that's not very likely, realistically. You know, you have a model, it works for you. So you need to mitigate, you need to address, you need to have a program. And there are essentially three prongs. Public, your government has to work with other governments to sort of, okay, you know, you're going to have this sort of substitution recognition, equivalence. How does it work? You know, you're going to have definitions. You know, market makers buy equity. What's reasonable? You know, and that debate, the academic debate, Cambridge instituted a program, I believe, Judge Center, I think it's called. Hong Kong is apparently on its path to instituting the program. So you're going to see regional thought centers. You're going to see this program in Hong Kong, if it thrives, and I have every reason to believe it will thrive, be a thought center for the Chinese government, for the Chinese companies. Where do we go from here? How do we see extraterritoriality? Good thing, bad thing, but we need to respond to it. You cannot be surprised with a $2, $5, $9 billion fine. And finally, private. You really, you know, have to get involved. If the New York Department of Financial Services is fining you billions of dollars, you need to work with them. I mean, you can take the current option, complain, agonize, talk about the 30 Years' War, or you can work with them. You have to be involved with definitions. You have to know what words mean. You know, if sanctions include high-pressure pumps, what is a high-pressure pump? If you want the definition in there, that means Bank of China has to pay somebody to be at the New York Department FS hearing to raise his hand and say, hey, hang on a second now. So you talk about, you know, market making, reasonable securities. What is reasonable? How much? And just sit there and keep saying how much till they throw him out of the room. So you have to respond. And very important part of the response we'll take here. Anyway, so enabling laws, regulation, language, convergence. It just got me back to my initial topic, so I wanted to throw it in. And increase capacity. So, Pax Americana, move from trying to persuade everybody that we're right. You know, you should have our securities law because it's the best securities law. Now we've moved to you should have our banking law. Q. You know, that's sort of a way of persuading. And my favorite quote from the former and first supervisor of banking, how easy it was. Devolution of enforcement from courts to agency will continue. Substantive legal arguments, appeals to international law, not effective regulatory. Because again, and this is very important. You know, it's sort of in 20 years I've been at law, we've never lost a case. Doesn't mean we're brilliant. I'm not using the royal we, sort of people I work with. Doesn't mean that I'm brilliant. It means that you sort of should be able to see where you're headed. You sort of should be able to see that, you know, if your client has deficits, accept them, settle, walk away. And the problem is that the way we use for addressing, we're using a language suitable for courts in a situation that is completely different. Regulatory agencies are absolutely, well, maybe they're not disinterested, but they're absolutely immune to discussion of Westphalian principles. It just doesn't work for them. They have a reg, which they interpret, and it's an aside, but regulatory agencies function as all three branches of government in one. You know, they're a legislature because they decide what the poorly drafted regs mean, which don't have precedent or anything else behind them. They are the executive because they decide who they go after and for how much. And they're adjudicators because, well, most of it takes place within their agency. You know, when somebody, you sort of, again, I've always, and I never had that privilege, as closing comments, I've always wanted to be in that room where you sit with somebody from BNP Paribas and say, you really should give me $9 billion. Why? Because you're a bad guy. Okay. Anyway, thank you for coming.
Thank you very much. That was very, very interesting. I see that we're beyond our expected completion time, so if anyone needs to leave, feel free to leave at any time. But I think we can stick around for a few questions or comments. Anyone want to begin? Yes.
Presumably that's only as good as long as the US dollar remains in Russia.
End of history. You know, Russia has been telling us about the rotting West since TV was black and white. You know, from the days of 3 Russian TV channels, Channel 1 was propaganda, Channel 2 was ballet, Channel 3 was a guy telling you to get back to Channels 1 and 2. The West has been rotting for so long that, and yet, the problem is that transacting is convergent. Transacting is integrated. The argument that somebody would abandon a working, effective, cost-effective, regulatory effective model in favor of something ideologically driven, transactionally is ridiculous. It's a good political argument. You know, that Indonesian, and I worked in Jakarta, and I heard it, that, you know, our independence requires that the rupee, but it's not going to happen. So waiting for the dollar to die, I'm 48, I don't have the time. You know, I don't think it will happen in my lifetime. And the problem is that it's like anything else. It's one of my favorite stories. We were doing a $16 billion project finance in Russia when I was working for the US government. And in a room, this was in 1994, there was an elderly Russian law professor who said to an elderly American law firm partner, he said, I don't understand. I have written books on project finance, I have taught project finance, and I make $400 a month back then. You make $400 an hour, why? And the American partner, translating into appropriate language, said, it's like marital relations. I do it, you write and read about it. And the problem with transacting, it's very hard to imagine a different model.
That presumes that politically, the China
No, not at all. But if it... If I was looking to fight extraterritoriality, I would fight tooth and nail for territorial law. I would fight tooth and nail for movement away from closed room, no record regulatory proceedings to court proceedings. I would tell BNP Paribas, you know, take your chances. You're not going to do much worse than $9 billion. Go to court. It'll be in 5 years. But one of my favorite statistics, and again, SIPS is very interesting. I mean, if it works, it's very interesting. But, and again, I'm quoting, I think it's South China Daily, and they said that 10% of world transacting is in RMB right now, out of which 0.4% is processed in RMB. Now, again, you can build a model because it's the right thing to happen, because, you know, you shouldn't have one Pax Americana. You can build a thought model that says, yeah, we're going to move away from that. But statistically, if you're at 0.4% of 10%, that you are going to, you know, it's unlikely. It's not likely to happen in yours and mine transactional legal working life. But it may happen at some point.
Yeah, I think due process of law is the conflict in the United States Constitution. So how do the regulatory offices of U.S. are not following the U.S. Constitution?
They don't care. They're not the least bit interested.
Say when the president is not following the Constitution, I think the Supreme Court judge can do something.
For the courts to do something, you have to have a case. I'm not clear what the constitutional violation would be. But again, you are talking about an administrative agency. Imagine you're in a Chinese administrative agency. Imagine, you get twice the gas or water bill you're supposed to get, and you come to me and you say, the Constitution, damn it. Okay. And they will tell you, I have a job. It's one of my favorite moments. When I was a very young lawyer, I used to work in Republican politics, and we had a case in a very Democratic district where our person verifying the signatures was told that he's engaged in political activity, and therefore was to stand 50 feet away from the signature to verify it. So the clerk would hold up the signature from 50 feet away, and he was supposed to verify the signature. And I called up the clerk and said, look, you're insane. There's a law. What are you doing? And she said, and I'm quoting, I ain't got time for no law. I'm running an election. They don't have time for you and me. They don't have time for the Constitution. They're not interested. Because there is no individual employee at whatever the utility administering gas bills in Hong Kong that's responsible for compliance with the Constitution. They're not rewarded for it. They're not punished for it. They don't care. Besides which, short of a court ruling, you don't have a constitutional violation. And what do you feel it violates, incidentally?
Due process.
What do you feel it violates? Fair enough. Let me ask you a question. What part of the Constitution applies to let's say, United Bank of Switzerland? They're not U.S. nationals. They're also not people, incidentally. In the spirit in the U.S. BNP Paribas is not in the U.S. It's not a U.S. legal entity. It's not anything. What constitutional? But again, to violate the Constitution, let's say we accept the argument that there's a violation. To violate the Constitution, you have to have somebody whose rights are violated. And I disagree with all my heart. I think Guantanamo is a disgrace. I think that our system should have tried them, should have executed them, and should have moved on to other things. But as our recent history proves, America can take people, keep them without proceedings, and no constitutional rights are violated. They're not U.S. nationals. They're not in the U.S. It's a bit analogous. You go to the Hong Kong Utility Board and you say, my gas bill is twice the size it should be. You have violated the U.S. Constitution. It's not. It's sort of the problem with constitutional law. It's sort of our constitutional law professor had this wonderful line. When you think of an issue of constitutional law, you set it out, and if you go, probably not. If you go, it may be. And the problem is, to have a constitutional law claim, one, you need a violation. There is no settled ruling that you're entitled to court due process. I very much doubt that New York Department of Financial Services violated its own regs. They applied regs as they honestly believed them to be applied, to somebody they honestly believed to be a bad actor, who agreed to enter into a settlement. They weren't tried. I don't know how Rabobank persuaded its employee to come and go to jail in New York, but he did come to New York court and pled guilty. But essentially, what would be your standing? If, let's say, you're Bank of China in Hong Kong, what is your standing to allege U.S. constitutional violations?
I'm going to have to cut this dialogue short because there's a class that's waiting to come in. So it's been an extremely interesting and engaging seminar. Please join me in thanking our speaker, Mr. Back.
Thank you for coming. If you would like the PowerPoint or the underlying paper, I'm more than happy to share.